A lot of gun owners think the Supreme Court changed one gun rule and moved on. That is not what happened. It changed the whole playbook, and 7 gun law rules shifted right under your feet. Pause. Quick question before we continue. Are you subscribed? Because what I'm about to reveal could keep you from making a very expensive mistake. Hit that button now, because most people only learn these changes after a stop, a charge, or a court case. Here's what shocked me. Most headlines covered one case at a time. Bruen, Rahimi, Cargill, VanDerStok. But almost nobody stepped back and asked the bigger question. What changed for regular people? For your carry permit? For what counts as a banned item? For who can still be disarmed? For what the government can regulate? And how? So in this video, I'm going to break down 7 real legal shifts in plain English. No lawyer talk, no fluff. Just what changed, why it matters, and where people get tripped up. First thing, the court knocked out the old prove you need to carry rule in states that used it. Before Bruen, some states made you do more than pass a background check and training. They wanted you to prove a special reason. Not just, I want to protect myself. They wanted something extra, like a documented threat, cash business, or unusual danger. If you were just a normal person who wanted to carry for self-defense, that was often not enough. The Supreme Court said, no, that kind of rule goes too far. The court said law-abiding people with ordinary self-defense needs have a right to carry in public. That sounds simple, but the effect was huge. If your state used a may-issue system, where officials had wide freedom to say yes or no based on your story, that part took a direct hit. Here's a real-life way to think about it. Imagine you work late, drive home alone, and want a carry permit. Under the old-style rule, an official could basically say, that's not special enough. After Bruen, that kind of special needs filter is the problem. The government cannot treat your right like a favor. But here's what most people get wrong. Bruen did not erase every permit law. It did not mean permits are dead. It did not mean every carry restriction vanished overnight. It killed the idea that you must prove you are more deserving than everyone else. Second, objective permit rules mostly stayed alive. Now, this is where it gets interesting. A lot of people heard about Bruen and thought, great, permits are over. That is not what the court said. The court went out of its way to say shall-issue systems can still be okay. That means states can still require objective things like fingerprints, a background check, a fee, or training, as long as those rules are not abused to block normal people. That matters because many gun owners made a dangerous mistake right here. They heard Bruen and assumed every permit rule was fake. Then they carried where they should not have, or they skipped the permit process in states that still require it. Don't make that mistake. Most people think Bruen meant do whatever you want. The truth is much narrower. It meant the state cannot force you to prove some rare special danger before letting you exercise the right. Here's a hypothetical example to explain this. Let's say your state says you need training, fingerprints, and a clean background check. That may still stand. But if the same state says, tell us why you personally deserve to carry more than your neighbor, that is the kind of rule Bruen went after. So rule change number 2 is just as important as number 1. The court did not blow up carry permits. It split permit laws into 2 piles. Subjective rules got hammered. Objective rules had a much better chance to survive. Third, the court changed the test judges use in gun cases. This is the part nobody talks about, but it may be the biggest one. Before Bruen, many courts used a 2-step test. In plain English, judges often asked 2 things. First, does the Second Amendment cover this? Second, even if it does the government have a strong enough reason to limit it? Bruen rejected that second balancing approach. And the court said judges should not treat gun rights like a math problem where the government stacks up policy reasons and wins. Instead, if the plain text covers the conduct, the government has to show the law fits the nation's historical tradition of firearm regulation. That sounds technical, so let me translate it. The fight changed from, is this law a good idea, to, do we have a strong historical tradition for something like this? And that one shift sent shockwaves through almost every gun case in America. Why does that matter to you? Because it changed how courts look at carry laws, possession bans, age rules, place bans, and even parts kit rules. It changed the courtroom language. It changed what evidence matters. And it forced states and the federal government to defend laws in a very different way. When I found this out, I couldn't believe how few people were talking about the practical effect. Even if a law stays on the books, the whole legal fight around it is different now. If you're finding this helpful, imagine what you'll learn in my next video about the 5 words that can protect you when police ask about your gun. Subscribe so you don't miss it. Fourth, the court said dangerous people under certain domestic violence restraining orders can still be disarmed. After Bruen, some people started saying a lot of possession bans are about to fall. Then Rahimi came down and the court drew a very important line. The law at issue was the federal ban on gun possession for people under qualifying domestic violence restraining orders. The Supreme Court upheld that rule as applied to Rahimi. In simple terms, the court said if a court has found that a person poses a credible threat to someone's physical safety, that person can be temporarily disarmed. That is a huge change in the post-Bruen story because it tells you Bruen was not a blank check. Let me explain why this matters. Imagine someone says, the Supreme Court now says the government can't disarm anybody unless there is an exact same law from 1791. That sounds dramatic. It is also wrong. Rahimi says the government can disarm someone who has been found by a court to be a real threat. But here's the crazy part. The court did not say the government can disarm anyone it dislikes. It did not say officials can wave around the word dangerous and call it a day. The ruling was tied to a court finding and a clear threat. That detail matters. So if you hear somebody online say, Rahimi means all prohibited person laws are safe, slow down. That is not what it said. And if someone says, Rahimi means domestic violence orders do not matter anymore, that is also wrong. Now, quick legal note, this is educational information, not legal advice. Always consult an attorney for your specific situation. Fifth, Rahimi also quietly softened how strict Bruen looked at first. This one is easy to miss, but it matters a lot. After Bruen, some lower courts acted like the government needed a historical twin. Almost the same law, almost the same facts, almost the same setup. Rahimi pushed back on that. The court basically said, the government does not need a dead ringer from history. It needs a good historical analog. That means something similar in principle, not identical in every detail. That is a very big deal. Think about it like this. Cars did not exist in 1791, but roads did. If a rule today solves a similar safety problem in a similar way, courts may look at the older tradition and say, close enough in principle. That is the kind of move Rahimi approved. Why should you care? Because this affects cases still moving right now. Drug user bans, felon in possession challenges, under 21 restrictions, sensitive places, private property carry rules. All of those fights now happen in a world where Bruen started the test, but Rahimi explained it is not a museum game where modern laws lose unless history gives you the exact same object. Here's what most people get wrong. They think Bruen was all gas and Rahimi was all brakes. The truth is, more complicated. Bruen expanded the right to public carry and changed the legal test. Rahimi kept that test, but told lower courts to use common sense and analogy, not fantasy-level exact matches. Hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the gun owners who want the real story before the next ruling drops. Click subscribe. Sixth, the federal bump stock ban got knocked out, but not for the reason many people think. This is where people get themselves in trouble. They hear Supreme Court struck down the bump stock ban, and then they stop listening. But you need the second half of that sentence. In Cargill, the court said the federal agency went too far when it treated bump stocks as machine guns under the federal statute. The key point was how the law defines a machine gun. The court said a semi-automatic rifle with a bump stock does not fire multiple shots by a single function of the trigger, and it does not fire automatically in the way the federal law requires. So yes, the federal rule fell. But wait, there's something even more important. Cargill did not say every state must allow bump stocks. It did not erase state bans. It did not say bump stocks are protected everywhere. It said the federal agency could not stretch that specific federal statute that far. That means you could be legal under federal law and still in serious trouble under state law. Imagine you watch one short clip online that says bump stocks are legal again. Then you buy one in a state that still bans them. That is exactly how people walk into charges they never saw coming. So rule change number 6 is real, but it comes with a warning label. Federal law changed here because of how the statute was read. Your state law may still say something very different. Seventh, the court said some ghost gun kits can be regulated like firearms, but not every unfinished part is automatically a gun. Now, this is where the story takes another sharp turn. In VanDerStok, the Supreme Court upheld the ATF rule against a broad facial challenge. In plain English, the court said the federal government can regulate some weapon parts kits and some unfinished frames or receivers when they are close enough to becoming a working gun and can be readily completed. That means some kits can be treated like firearms for federal regulatory purposes. Think serial numbers, licensed sales, background check rules, and certain sales channels. The exact details can get technical, but the big point is simple. A box of nearly ready parts is not automatically safe from regulation just because it is not fully assembled yet. But here's the part nobody's talking about. The court also said there are limits. Not every chunk of metal, not every piece of plastic, not every unfinished object becomes a gun under federal law. Some items are still too far from finished to count. That makes this one of the easiest areas to misunderstand. Most people think the rule is either ghost guns are totally banned or unfinished parts are totally free. And the truth is right in the middle. Some readily convertible kits can be regulated. Some rough, incomplete items may not qualify. Here's a hypothetical example to explain this. If a kit includes what you need to build a working pistol quickly with common tools, that is much more likely to be regulated. If it is far from complete and needs major work, special tools, time, and expertise, the answer may be different. And if you don't know where your item falls, guessing is a terrible plan. Laws change fast. Court rulings change faster than rumors, but rumors spread first. Subscribe now, because the next video breaks down the gun cases that could change carry locations, under 21 rules, and prohibited person laws next. So what is the big takeaway? The Supreme Court did not simply make gun laws looser or tighter. It redrew the map. First, it knocked out special needs carry rules. Second, it left objective permits standing. Third, it changed the legal test. Fourth, it said people found by a court to be a real threat can still be disarmed. Fifth, it said history does not need to be an exact twin. Sixth, it struck the federal bump stock rule. Seventh, it allowed regulation of some ghost gun kits while warning that not every unfinished part is a firearm. Pause.